Well, welcome to the Snowbirds Expat Radio Podcast. I'm your host, Jerry Scott. Today's episode, we're going to be discussing Canadians doing business in the US. And we're going to be talking about this from an immigration and a tax perspective. And we really do have, once again, the map covered. We've got Julia Herzog, who's from Victoria, BC, which I grew up on Vancouver Island. So I know the island very, very well. And then we also have Robert Clegg, who is actually just a hop, skip, and a jump down the road from our office in Coquitlam. Robert is in Surrey. So before we get involved in this very, very interesting topic, because so many people that I come across that live in Maui or Palm Springs or Scottsdale, they always say that they'd love to spend more time here. How can I get a business going here? How do I get the E2 visa and process the whole works? But before we really get into this, I want to hear more about Julie, more about her background, and more about the firm that she founded, and then we'll get into Robert as well. So go ahead, Julie. Tell us more about yourself, Julia. Sorry.
It's Julia or Julie, either works.
Okay.
So I do live in Victoria, BC, but I'm a transplanted New Yorker, originally from New York City. I am a graduate of Cornell University, and I obtained my law degree. I'm a transplanted Canadian, so I'm a dual citizen. I obtained my law degree at Osgoode Hall and a Master of Laws at University of Victoria, and a PhD in the Faculty of Human and Social Development at the University of Victoria. So an interesting sort of pathway. And my pathway, it is aligned, like my education is all tied to my history, sort of my history, as my interest in immigration came because I was working as a Crown prosecutor, and I became interested in helping individuals and advocating for individuals. And specifically, immigration stems from my past as a granddaughter of Jewish refugees from Eastern Europe. So I focused my practice after working as a Crown attorney in staff in both Ontario and British Columbia. I switched over and began to focus my practice on immigration law in about 2009. And I have a small practice, private practice. My focus is on business immigration. I have a partner who is my husband, who comes from an entrepreneurial family as well, also comes from an immigrant family. And he has years of experience in consulting with a wide range of small businesses and large businesses, everywhere from small retail all the way through to large telecommunications. So my partner, Howard, works with me on business plans and tailoring those business plans to the U.S. immigration requirements. Now, I just wanted to talk a little bit about doing business in the United States. And I guess, Jerry, you might have some questions for me, so I don't want to
do
monotone.
Yeah, and one quick question. I just want to do the introduction to Robert as well, because this is the first time we've actually had an accountant and an immigration lawyer on the same time, and Robert being the cross-border. So we'll quickly do the introduction on Robert. Tell us more about your firm, yourself, and then we'll jump into the questions for Julia, and we can take it from there.
Sure, thanks, Jerry. Little side note, I'm actually located in Victoria, British Columbia as well.
Oh, how did I get the Surrey? Okay.
Our firm's managing partner is located in Surrey. So we handle a lot of clients, both Lower Mainland and also on Vancouver Island and beyond, for sure. A little bit about myself. I grew up in Washington State. I've been in Canada for about 16 years. My first degree from Washington State University, graduated back in 1990. It was, I studied history and I also studied accounting. Went to law school at Gonzaga University in Spokane, graduated in 94, and then went to the University of Washington for my master's of law in tax and accounting. Graduated there in 2003. And since 2003, I have been exclusively practicing in accounting. From Seattle, I was picked up by a Big Four firm and then transferred to Calgary, where I spent 6 years in the cold. And then I left Calgary and joined a couple of former colleagues from that firm here on Vancouver Island. So we've been, exclusively practicing in U.S. corporate, personal, handle clients all, mostly in Western Canada, Western United States, Hawaii, California, Arizona, lots of domestic, lots of cross-border clients here and in the United States. So it's kind of a little bit of background about myself.
Well, remind me to follow up because we do have clients in Hawaii that have a lot of questions regarding state tax and
For
how
sure.
they have to deal with the RSPs and how they're taxed, like the state of California. So we're going to jump into the questions for Julia here. And once again, like I say, this is a real treat for us to have an immigration and the tax on the same podcast. And we'll go through the questions. We're going to cover some questions with Julia, and then we'll jump into Robert, into your expertise as well. So the first question we have is, what type of activities are permitted for business visitors to United States?
Yeah, that's a really important question because people from Canada often kind of forget that we have a border. And I get a lot of people who have had trouble at the border, basically from not realizing that they were supposed to have a different kind of status, some kind of visa or some kind of status. So just to sort of talk about, we're talking about temporary visitors. This question is, in response to a question about temporary visitors. So this isn't talking about long-term visitors. And even a business visitor, all visitors have to have a residence in the foreign country, that is Canada, and intend to come into the United States for a very specific period of time. And they seek admission for the sole purpose of either pleasure or permissible business activities. Well, what are the permissible business activities? I usually say it's kind of like the moral of the story for in Aesop's fables. We have a legal case called the matter of Hira. It was a Hong Kong tailor, and the tailor would come to the United States to measure his clients for suits, and then he'd go back to Hong Kong. He would construct the suits there and be paid to his account in Hong Kong. That is permissible. That is the sort of the basis. That was a 1966 case, and that is the contemporary basis for what is permissible business activities as a business visitor. And Canadians do not need visas. So if you're coming in as a business visitor and you're doing permissible activities, you don't need a visa and you don't need any particular status. But what people often don't realize is it's very restrictive what you can do. So you can, and I'll just give you the quick list, is you can engage in commercial activity, transactions, just like the Hong Kong tailor measuring suits, and it could be a service. It doesn't have to be a product. You can negotiate a contract. You can consult with your business associates. You can litigate. You can participate in a scientific, educational, professional, or business convention, conference, or seminar, or you can undertake independent research. So the problem is when people engage in activities that are not part of those permissible activities. And there are, some sort of very specific additional things that people can do. But basically for doing business, it's what I just listed, plus if it's in the contract, after sales service. So that's usually for selling some kind of equipment, and the person has to go back to the States to service the equipment, but it must be in the contract. So that's the temporary visitors. And the reason why it becomes a great concern is that there is something called an expedited removal order. And should somebody participate in impermissible activities or attempt to request admission to the United States They are vulnerable to an expedited removal order based on a lack of valid entry documents. So, what is the impact of the expedited removal order? That is a 5-year bar to the United States, and that could be remedied possibly by a waiver application, and that's a whole other topic of seminar, so very complicated. So whatever you do, as a Canadian doing business in the United States, you don't want to be vulnerable to the expedited removal order. And so then we go on to say, and I don't know if, Jerry, maybe you want to interrupt me and ask questions, just let me know.
You know, there's a thought that kind of came to mind is that, you know, under the B1 visa, which is the business visa, the business visitor visa, a lot of times these employers will write a letter or have a drafted lawyer. So when you go across the border, so if you're asked or you should be presenting that to the customs officer, is that common? Have you heard much about that under that B1 structure?
It's a B2 is the business visitor.
Okay.
I believe, but at any rate, it doesn't really matter. It's the alphabet city of you know, the thing is that people could get letters but what matters is not what the letter, whatever the letter is, you're probably thinking about something under a trade agreement. It is the structure. So what type of structure you're probably referring to is under the USMCA, which used to be NAFTA, the United States, Mexico, Canada agreement. In Canada, it's called the Canada-US-Mexico agreement. So in the US, it's USMCA. In Canada, it's CUSMA. At any rate, it's a cross-border trade agreement between the United States and Canada and Mexico to allow for the mobility of professionals. Now, in that case, yes, there is a application that can be made, and it often includes a letter from an employer. It's a very specific type of letter and very specific type of professions that can do that kind of work. And there's a list of those professions. They're usually called the TN professions after NAFTA, but they're very specific, usually requiring at least a bachelor's degree, most of them. And they're in very specific fields that are fields where there's a lot of need, I would say, or a lot of need was determined. It's a little bit behind the times as far as I think what is needed across the border. But what the specific thing is that you need a Canadian and American employer or entity in order to be able to get that status. And that status for Canadians is temporary. It can be for a period of 3 years, and then you have to keep renewing it. And you have to always have the intention of returning back to Canada. So from there, when a client does not fit into that category, I start thinking about business visas. And you mentioned the E2. So there's the E1 and the E2 treaty trader and treaty investor visas. A lot of small businesses in Canada are eligible for the treaty trader visa, and they don't know about it. Okay, so anybody who's doing a fair amount of trade with the United States may be eligible for a treaty trader visa. These are excellent mechanisms for being able to travel fluidly between the two countries and live in the United States if one wishes, but it could be part-time. One could be living in the US full-time, just so one meets all of the requirements of the treaty trader visa. So I'll tell you what those requirements are for a moment, and then I'll tell you a little bit about the treaty investor visa. And these are really big topics. These are complicated visas. I take care of them. And I guess the secret or the hidden part about the treaty trader and treaty investor visas is they're really excellent even for very small businesses. You do not have to be a large business to obtain one of these visas. And I kind of specialize in the tiny businesses or the small and growing businesses because to me, they're fun. And my partner, my husband, is from an entrepreneurial background. He grew up as his family owned a store. And it's a fun kind of effort for me to get to know somebody's business and help them grow the way they want to grow. So for treaty traders, you have to have sort of the enough volume of trade, either by transactions or by revenue, to qualify for the visa. You have to be a citizen of Canada, or your business has to hold Canadian citizenship, and I can explain that. And you have to have your 50% or more of your international trade must be with the United States. So it's not the Canadian trade. It's just if you take out your international trade, your trade with the United States, you're a Canadian, and your trade with the United States and Europe, for example, more than 50% or more must be with the US. So that's the kind of criteria. So that's the treaty trader. The treaty investor is also based on our treaty, the US treaty with Canada. And it can involve a small business. The business must be putting their investment at risk. So they have to have taken the money, and it has to have been invested. And if you're purchasing a business, that would count as at risk. If the contract has not gone through yet, what you do is put the money in. I would definitely not purchase a business without knowing you have the visa. You put the money in an escrow account pending the approval of the visa. So that's the investor visa. So irrevocable commitment of funds, and the funds have to be substantial enough. Now, this is an area of discretion for the decision maker is the Department of State, is the Foreign Service Officer. So the Foreign Service Officer is going to look at the business, and if it's a small business, it would be a higher percentage of funds. So for example, if the business is worth $100,000 and the investment is $100,000, and that would fit that criteria. Although I can say that even smaller businesses have qualified. So it's not a number or an amount of money, it's a proportion. And if it was a large business, say $100 million business, then a $10 million business investment is sufficient. So they do this proportionality test or proportionality analysis. The visas are good for 5 years. At least the company registration is good for 5 years, and the employee or the chief executive officer or the director or owner of the business will get a 2-year visa in their passport that will be renewed as they travel back and forth every 2 years. So that's in a nutshell the business visas.
Now, one quick question here is that the question is always coming up. Now, when you say, because we know that the E2 visa process takes a while. We know that if you actually buy a business, or if you focus on a business, or you target a business you want to buy, like you say, like you try and put the money in escrow before you can get, to make sure your visa is approved. But isn't that kind of like a 2-year window or a year and a half? Like, what is the average time it takes to get a E2 visa from start to finish if you have this business that you're looking to purchase?
Well, I can't testify for other practitioners. I think because I work with small business people and we work closely with them, that we're faster, perhaps, because it does not take a year and a half. Or perhaps you're thinking of the situation with COVID when the consulate was not offering interviews for a long period of time. So at this point, what happens is you have to apply for registration for Canadians. You have to apply for registration of your business, your Canadian business or your new US business. It depends on trade, and investors have a slightly different way of talking about them. But they have to go to the US consulate in Toronto and submit the application gets submitted. The time lag there's 2 time lags. One, the main time lag I encounter is the client being ready to give me all of their financial documents so that I can prepare, or my partner can prepare the business plan, and we can prepare the application. So it takes a client quite some time. Usually it depends on how fast they are or how up to date their bookkeeping is, a month, 2 months. It depends on the client. And then we have to we submit the application to the consulate, and we're waiting for an interview. The lag time for the interview, maybe a month now, maybe 2 months. And then once they get their interview, usually the turnaround time is immediate. It's sort of like 2 weeks later, they have their visa. So it really depends on the individual business and the individual circumstance, how long it's going to take. The consulate is much more efficient lately than it had been.
So the purpose is that if you target a business, you put the money in escrow, you call up Julia, she can expedite that process as best as she can. And so once you get your visa, then you're able to close on the business.
Exactly. Once you get your visa, you can close, and then you can go ahead and you'll have your visa and your passport. You can go ahead and work in the US, live in the US, live part-time in the US. It depends on what people's situations are.
Okay. Well, that's interesting because, like I say, we come across this a lot in when people fall in love with their happy places, may it be Maui or whatever the case is. Nobody wants to leave Maui. And I've seen some of the saddest people sitting there. When you jump off the plane in Maui, you're walking by all these people that are waiting to go home, and very seldom do you see smiling faces. So that's good to know. So we'll keep that in mind, and we'll make sure that people do get to know more and more about Julia and the services that she provides. And if you've never been to Victoria before, Victoria is such a beautiful place. I'm being a little biased because I did grow up in the island. Okay, so I'm sure we're going to go back and forth, but we're going to jump into some of the tax questions, and these are the things that are important. So we'll start off with the fact that you've bought your visa. You've bought your business. You got your visa. You were able to close in your business. Now let's bring in the cross-border tax guy. And Robert, thanks again. It's great to have both an immigration and a tax person, cross-border tax person, on the same call. So really the first thing is that what activities, based on the permissible activities for business visitors, what tax filings, if any, would have to be required? And we must be talking about the US side of things.
Absolutely. Yeah, we're going to be talking about the US side. So oftentimes we'll see, Canadians that spend a large number of days in the United States each year in successive years. So, if you're just simply there on vacation, you're retired, you're the quintessential snowbird. We always have to be mindful of what's called the physical presence test. And this is more for your B1, just the visitors, right? They're not conducting any sort of business activity. They're there for pleasure. So the US has this rule where you take a 3-year average of the number of days that you're physically present within the United States. If you meet the average and you're under, in the current year, 183 days, anywhere from 30 to under 183, and you average, say, 120 days, or I think it's 122 days, then you meet that physical presence test. If you aren't required because of some other reason to file US tax returns, which I'll get to in a minute, you really should. It's advisable to file what's called an 8840, a form 8840 with the IRS. It's called an 8840 closer connection exception. And so what that form does is it's a checklist where you are alleging that your connection remains closer to Canada, and notwithstanding meeting the physical presence test, you are considered for tax purposes a non-resident of the United States, and your residency remains with Canada. Because if you don't file it and you meet the physical presence test, then you will be taxed like any other American citizen, green card holder, or illegal aliens that just simply overstay their visa, right? Which you would essentially be taxed or could be taxed on a worldwide basis, which could render disaster, right? For Canadians that spend extended amount of time in the United States. So we see a lot of that. We also see a lot of folks, Canadians, they may spend 2 or 3 days in the United States, but they have rental properties, or they have interests in oil and gas properties, or they're limited partners in large partnerships that hold and operate and rent apartment complexes, single family, multi, that type, and they're earning US source rental income. By holding those types of investments, those clients are actually engaged in a US trade or business. In case of a rental, that would be a rental business. And that's permissible. Because it's a rental business and because it's a piece of US real property, the Canadian owner or limited partner, whatever the case may be, is required to file a non-resident Form 1040 NR from inception until sale. Very important first-year elections need to be made, which will treat the Canadian taxpayer filing Form 1040 NRs on the same basis as a US taxpayer. In other words, they will be taxed on a net rather than on a gross basis, right? So withholding would not be required until that real property interest is sold. Then FERPTA, HARPTA, Hawaii, right? Various states have their own non-resident withholding regimes. And then annually they would have to file, they would have to pay federal and state tax on whatever earnings they might have. But the good news is, because the foreign tax credits align perfectly with their Canadian filings, their T1s, they would be entitled to a foreign tax credit with the CRA, which effectively eliminates double taxation, right? So you'll pay on that US source income tax first to the United States, federal, and also the state, wherever it's wherever that property is situated. And keep in mind, not every state has an income tax system. Washington, my home state, does not. Nevada does not. Alaska does not. But Hawaii certainly does. California does. Arizona does, to name a few, right? Those are the big ones I see, right? Not that the weather is bad in Canada, but the weather's bad in Canada. So a lot of folks want to get their vacation property somewhere in the Sun Belt, right? And so as long as you do that, you file annually until you sell it, you'll be fine. And the foreign tax credits align perfectly. So that's often what I see. I also see folks that have investments in oil and gas operations. They will receive various tax forms. Typically, if the company knows they are non-US persons, they'll receive what's called a 1042-S. That 1042-S will disclose the gross royalty from an oil and gas well. And more importantly, it'll have a box which shows federal withholding and state withholding. And that's just a dead giveaway that you're going to have to file a US return. In the event you don't, you're not going to get a refund, because withholding is typically more than your ultimate tax liability would be. But more importantly, if you don't file it, the CRA will not grant you that credit. Because always the CRA, if you file in your T1 foreign tax credit form, CRA wants to make sure that that tax was actually paid. And so they'll do three things. They'll send you a letter. The letter will say, hey, we need to see the withholding slip. We need to see your tax returns, both federal and state. And we also need proof that those taxes were paid and that you actually filed your tax returns. And without that, the foreign tax credit with the CRA will be denied, and then you'll be double taxed, right?
You know, I've got, I wasn't quick enough. I was going to interrupt you for a second because when you started talking about the 3-year rule, the current
For
year,
sure.
2 previous, you put a great plug in for the Snowbird US Day Tracker, and the check is in the mail. So
Yeah.
there you are.
Oh, yeah.
Another thing that really comes up a lot is there's always confusion for these snowbirds that yes, the IRS is the first thing you want to really be careful with, the 183 and filing the 8840. But for whatever reason, there's so much misinformation out there that they believe that there's an immigration, a 12-month rolling calendar for the average snowbird. And I know there is tax. There's a rolling issue around tax for 182 days, but there's nothing around immigration for a snowbird, is there? Oh, you're on mute, Julie.
In terms of immigration, the practice is for I'm talking about Canadians. Canadians are visa exempt. So there's 2 things that are important to note. The practice at the border, and I hear this at conferences, is that you do not want to be in the US more than 6 months in a 12-month period. And it used to be that people believed that the 6-month period would restart if you exited the US and came back into Canada and then went back. But that is not the practice. The practice is that if you're in the US for more than 6 months in any 12-month period, some alarms are going to go off and some conversations are going to have to be had in the secondary inspection area of the border. So I always advise clients to consider that. If they need to be in the United States for a longer period of time, that they should think about other options than coming as a visitor. I don't know. Did I answer your question?
No, I think that's from a tax perspective. They're always telling Canadians never be in the country for more than 182 days. Is that correct? That's really what it is. 182 days from a tax perspective.
Yeah, 183 days in the calendar year. If you or say, and I have a lot of Canadian clients that actually work in the United States. They're on TN visas, right? See that quite often, software engineers, so on and so forth. But they maintain their Canadian tax residency. You know, maybe their spouse is here, their property's here, everything's here. So if you're over the 183 days, you in the current year, you will not file the 8840, you'll file an 8833. Under the treaty, there's an article, it's Article 4, and it's the residential tiebreaker. And so very similar to the 8840, but because you're over that 183 days, you have to file the 8833 and claim an exclusion through Article 4 of that treaty. And basically what you're saying is that you're in the United States on a temporary basis, work, your economic center of interest remains in Canada, your family remains in Canada, your investments, your house, your principal abode remains in Canada. Therefore, IRS, I am not a resident of the United States for tax purposes. I remain a non-resident. I will file a 1040-NR and remain a tax resident of Canada. So as long as you do that, you're going to be in good shape.
So and the immigration, just to interject, the immigration regime is quite separate from the tax.
Yes.
And that is a point of confusion that I've noticed.
Yeah, so I know a lot of folks in Maui here that are they are American citizens. You know, they worked on the East Coast for many, many years. They still have all their ties in Canada. They still have all their ties in the United States. They just file 2 tax returns. Or is there still supposed to be one? Can you technically have 2 residences at one time?
Well, if you're a U.S. citizen, green card holder, you have to file a 1040. You're treated as a resident for US tax purposes. Myself, I'm a resident here in Canada, so I file a T1.
Yeah.
I'm also a US citizen, so I file a 1040. And really where it gets complicated is when you have two different sources of income and you have to figure out the foreign tax credits to apply on the Canadian return as opposed to what you would apply on the US return. So I think the Maui residents there, they're US citizens, is that correct?
They're both US citizens and Canadian citizens as well.
But their residence they're no longer Canadian tax residents?
No, they're still a Canadian tax resident.
Okay.
They still live in the Lower Mainland, and they
Yep.
also live in Maui. They split their time 6 months. They go back and forth. It's not necessarily 6 months at any time. They just go freely and they file two tax returns, and they're a citizen of both countries for tax purposes.
For tax purposes, yeah.
And I'm
Yeah,
seeing
no,
more of that.
Yeah. Oh, go ahead, Jerry.
Yeah, I'm seeing more and more of that of people that, I guess I'm always, my understanding is that you had to kind of default to one country as your main residence, but I guess what you're saying, you can be a resident of both countries at the same time?
No, you can't be a resident of both countries. Like, for example, folks that, they're on a TN visa. They're from Canada. They filed as Canadian tax residents, and they intend on returning to Canada at some point. Maybe it's going to be a year, 2, 3 years, temporarily working in the United States. In that case, then they will file a 1040 NR, right? Because they're on a temporary work permit. And under the treaty, you can't be a tax resident of both. So you have to choose. And because they're on a TN visa, they're not US citizens and they're not green card holders, right? They remain citizens and tax residents of Canada. So then it makes better sense for them to continue filing a 1040 NR and then pick that income up on their T1s. I have situations where, and it is permissible, at least under the tax code, where they've been working in the United States for 3 or 4 years on a TN visa, and they decide to sever their tax residency in Canada, right? So they file their departure return, final Canadian return, put the CRA on notice, and then they begin filing as any other US citizen or a green card holder in the United States. So they subject themselves to worldwide taxation, but in the United States, and more importantly, in the state that they reside.
Yeah, what I was mentioning, that these people are American citizens, they're dual citizens, they're American citizens, they live here, they file taxes. They're also Canadian citizens, they go back, they split their time going back and forth. And I believe they file the Canadian returns as well. So in that situation, as a Canadian citizen and American citizen, they can be a residence. They can have residences in both countries. And
well, for tax purposes, they would remain a tax resident in Canada, right? And then they'd want to file that 8840. Yeah. And if, say, for example, they have a condo in Maui that they rent, then they're going to have to. Yeah, they'll have to file that 1040 NR.
Okay. The question I have a kind of on the same line of thought of Jerry. So if you're a Canadian citizen and a US citizen, you're a dual citizen.
Yes, yes.
It sounds to me, and maybe you can help us understand this, Robert, do you have to choose which country is your primary residence? If you're going between the two, how does that work?
Yeah, I mean, as a dual citizen, yeah, you can choose. For example, if I were to return to Seattle, I would handle my affairs. And Jerry, this is a whole nother podcast.
Oh yeah, no, I think it's very confusing because, like I say, these people they have their home, they have 2 homes, they have 2 lives, they've got bank accounts on both sides of the border, and they just go back and forth. And this is the part that's always been kind of confusing for me, is that I've always told that you had to kind of default. You could only be a resident of one country. And in this situation, it sounds to me like they're a resident of both countries. Well,
it sounds like they are, but technically they're not. So they're going to have to choose. Do they remain a tax resident in Canada If they were to sever, then they're going to have to determine, are they subject to Canada's departure tax, right? Because Canada has a departure tax when you leave.
Of course.
And would it be prohibitive in their situation to depart Canada? Secondly, a big one that comes up is medical. A lot of these folks haven't contributed to Social Security or Medicare to qualify for US Medicare, which means if they leave Canada, they lose their Canadian Medicare, and then they're paying for maybe $5,000, $6,000, $7,000 a month in the US if you're not on Medicare. So those are big considerations, right?
Yeah.
And then the third one, which is really unique to Canada, provincial, it's the provincial health services, right? Like BC Health. You can only be outside of British Columbia for, I believe, a maximum of 7 months.
7 months, yeah.
And remain on it. So even though you're, as a US person, I could be living in Hawaii until, I go out with the tide, so to speak, I'd lose the BC medical, right? If I'm there for a full year, even if I intend to remain a Canadian tax resident. So that's always a big consideration, is the medical.
Well,
I want
oh, go ahead, Julia.
I have a moment to interject. I just wanted to make sure that if we're talking about green card holders, that they are a very special category. And I don't think we have, and that is a whole other podcast, because they have requirements to be residents of the United States for a particular period of time and filing as US residents. So they're a whole other cup of tea that we can talk about another time.
Oh, for sure. And tax-wise, it's unique as well. So,
well, there's so much for us to discuss going back and forth. And I've always said that the podcast, and we were just after today's call, we set up this program on our Snowbird US Day Tracker app, where we're actually going to be able to, clients, when they turn it on, it'll prompt them to the next podcast. And we're always going to be talking about tax and immigration. So we'll do presentations, webinars too, where people can sign up, and we'll put together a great presentation. So, but the last question I have for Robert is the filing dates for both the United States and Canada are, if you want to tell.
Canada is April 30th. And the US, if you're, it's obviously more complex, right? So if you're living in the United States, it's April 15th. And states are generally April 15th. Hawaii is 1 week after the federal due date, right? If you're a non-resident filer, 1040NR, it's June 15th. But the states are typically April 15th, right? So you always have to be wary of that, right? Most states you can extend by virtue of a federal extension, right? So if you file a federal, it's going to extend the state. And then corporate returns are a whole different animal, so to speak, right? For example, if there are clients that are intent on immigrating through a business, like a e-visa, Julia was mentioning. It really depends on what they're going to be investing in too. If it's a regular C corporation, which I see mostly, right? They would then file what's called a Form 1120. That's federal. It's Form 100 in California, Form 120 in Arizona, and those due dates. Corporate with a December year end, it's 4.5 months, so it would be April 15th. And then if it's a fiscal year end, with the exception of September, it's 4.5 months. September being 3.5. So,
well, what we'll do for this this webinar coming up, we'll take someone from the dream to the actual reality, and all the steps they have to do with Julia on the immigration side, and making sure that B visa, the E2 visa is in process, if that's the route they take, right down to Robert, to making sure that you're 100% compliant. So on that note, we just want to tease people. We don't want to give them all the answers. So we'll save some of those answers for the webinar. But I really, truly appreciate your guys' time today. And having both of you on a call at the same time, immigration and tax, has been very, very interesting. So thank you for your time.
You're very welcome. Thank you.
Thank you very much, Jerry, for inviting us.
And I have to end every podcast, and this is the small town Ucluelet, Vancouver Island thing. My favorite saying in this world is be kind to all, the world is small. So once again, thank you for your time.
Thank you very much.
Thanks very much. Appreciate it.